Deportation for denied cases. The topic of today, Brian.
Yeah.
In February of 2025, the U.S. Citizenship and Immigration Services issued a memorandum outlining in what conditions they are going to issue notice to appear for cases that they're adjudicating.
Sure. Yeah.
Now, this is a resurrection from a memo that was issued back in 2018 and rescinded in 2021.
Yeah, Trump 1.0.
About the same topic.
Yeah.
And we're going to talk about it, spend a couple minutes explaining what this memo is about and what's there to watch out for and what's there not to worry about and what's there to worry about.
Yeah.
I'm Sam Shihab with the law firm of Shihab Burke, and with me,
Brian Burke from that very same place.
we practice immigration law throughout the U.S. We focus on employment immigration law and family immigration law. And today, as every Monday, we'll spend some time. Today, we'll be spending half an hour with you. And on Wednesday, we'll be spending another half an hour with you to discuss questions and concerns in the community or on any topic of interest. Today, we're going to talk about this new memorandum that was issued recently about issuing a notice to appear, Brian, for cases that the USCIS is adjudicating. Now, unlike the 2018, as probably everything with Trump 2.0 compared to Trump 1.0, it's more organized.
Yeah.
It's more focused and it's more detailed and maybe it has a more edge to it.
Yeah.
So they have issued this memorandum, provided more details about what they're going to do, and they broke it down in full details, Brian.
Yeah.
And we're going to go through the easy stuff first and then focus on the stuff that's relevant to a lot of people listening to us, which is basically employment cases and then also the family context, because within the employment there's the family, right?
Yeah, sure.
Always family immigration cases. Now there's a lot of NTA or notice to appear deals with other than family and employment, which we're not going to touch in details. Now let's begin by identifying what is a notice to appear.
It's short answer, it's the government telling you, hey, we believe we can remove you from the United States, and we're starting the process.
It's a charging document.
Yeah, it's like the complaint in a court case. Yeah.
Exactly.
Yeah.
You are here in the U.S. There are things that you have to admit or deny. It's like you're here in the U.S. You're here in the U.S. without a legal reason. You have no relief.
No grounds to say you can't remove me.
And therefore you should leave the country.
Yeah.
And you have to admit or deny the allegations and appear before a judge. It's a process that is not a fun process. It's a painful process because more legal costs, more uncertainty, more pressure, and so forth. So the government issued this notice saying, hey, I mean, they talked about a lot of things, but the core of this that deals with what you and I do every day representing our clients on the employment front and on the family front, if we deny an application, we may be issuing one of these for you right now, unlike we've done before.
Yeah, and I think that's what I want to highlight. There are tons of people in the United States who are subject to removal, subject to receive a notice to appear, who never get them because the government either doesn't want to in the past or hasn't had the opportunity to do so. And this is the government saying, our policy is to, here's all the circumstances we're going to be issuing them. And some of these are circumstances where we haven't seen NTAs, issued in the past. And now, going back to that, you said there's a memo a lot like this in 2018, right?
Right, June 28th, 2018 was issued, yes.
And as our colleague, Attorney Joe, is quick to point out, they had one of these memos last time. They didn't do much about it. And maybe we'll talk about what's different or how it looks now, and, there you go.
Right. Well, one of the very first thing I would say is never assume what happened last time will happen again at this time, because that would be the first mistake you will make.
For sure.
To assume otherwise, to take the full content of this memo, the four corners of this memo, and say, I got to pay attention to this, is the only smart thing to do.
Yeah, listen to what they're telling you, because they're telling you it for a reason, for sure.
So they break it down and they organize this memorandum. And then the first one they said, hey, listen, there are things we're required by law as a USCIS to issue a notice to appear. Okay, and they mention, for example, the one that's really most important in the family context is the removal of condition.
Yeah. That's when you've gotten a temporary green card through marriage, you either, I believe, if they deny your I-751 or you fail to follow your I-751 to remove the conditions on that temporary green card. Yeah.
And then they move quickly to the second one, which is the national security cases. Anything that is a danger for the national security for anybody, we need to remove those people. We've seen USCIS act on these things in some
curious ways, let's say.
Yeah, so obviously national security is a issue of a big concern, and clearly people who pose a danger to the national security of the United States have absolutely no business being here in the U.S., Brian.
Yeah.
But it creates some subjectivity because there's no court conviction on that one.
As to what is exactly, as to what is the national security and how do you endanger that.
The third one, which is the biggest one, which
makes a good segue. Criminal cases.
Yeah.
If you've been convicted of a crime that makes you deportable, and there's all sorts of those out there, they're supposed to put you in deportation proceedings.
Yeah. And without going too far, we are going to get to our friends at immigrationquestions.us right after this presentation, and we'll take their questions, and we've picked up a few questions from there to answer.
Yeah.
So these criminal cases are what they pose a threat to the public safety of this country.
You're doing crimes in the United States, we should remove you from the country.
Yes. Yeah. Then they move to one that's kind of controversial a little bit, which is we will issue NTA on cases that there is fraud and misrepresentation.
Yeah.
Now, this part of the memo talks about something very peculiar. It says that even if the fraud and misrepresentation is not the reason for the denial. Mm-hmm. So let's assume somebody filed for an F1 visa, change of status to an F1 visa. Mm-hmm. And the I-20 was deficient, and therefore this case is deniable. But there's another part that they feel that there was some misrepresentation. But if it's not material to the case, it's still, you can issue an NTA on it, which creates a lot of confusion as to what that means. What does that mean? And how can I have the opportunity to rebut? Because what's the number one thing that USCIS accuses people of doing all the time, unfairly and incorrectly?
I'm going to say being inaccurate on the forms in general. You say A on form, and turns out we believe B is true, but maybe you have something else in mind.
Well, no, that's true. That's exactly what it is. Is when they say there's something, some questions are tricky questions. Have you ever been arrested? This is a big one. Yeah. Have you ever been arrested? And
what's an arrest? I mean, what's an arrest is a huge, huge question. And where, like, I once had a case where we had to, it's only the police know whether you've been arrested. And what's the definition of arrest? It's wishy-washy. And, there you go.
Or when the government says, we think you misrepresented. And they do it all the time. And then at the end of the day, we give evidence that there was no misrepresentation.
Yeah, you guys are absolutely nuts on this one.
But they can issue an NTA.
Yeah, and so I guess that's one of those scenarios where, it's just basically they take from bad to worse. We're not just going to deny your case. We're going to put you in removal proceedings and essentially really complicate your ability to challenge our decision on that by doing so.
Then we move on to denials, Brian, and this is really where it's important. Denials for cases where there's in the employment-based context, when there is a signature on the application. So if you don't have a signature, for example, there's an I-140 denial, there's an H-1B denial, that does not trigger an NTA.
Yeah, so I'm glad you skipped this one because I want to come back to that one. But so on the memo, it says that they'll issue an NTA when the beneficiary is a signature on an I-129 petition. That's pretty rare. E-2s, maybe some self-sponsored H-1Bs. Those are the sort of scenarios where they might be issuing an NTA to people.
But here's a scenario. You file an you lose your job.
Yep.
And you're in the grace period, and you don't find another job.
Yep.
Now you file for a change of status to a B visa.
Yep.
And that B visa is denied.
Yeah.
You get an NTA.
Well, yeah. I mean,
now you get an NTA. On your case, notice to appear, and you're in deportation, and that is a problem. Also, the big one is the H-4. Your spouse or your children can get notice to appear on denied H-4. For example, let's assume a scenario in which you forgot to file an H-4. They run out of status, and you file one non-protunct, retroactive, with retroactive impact. But it's denied.
Well, yeah. I mean,
now here's what they said in 2018, Brian. They had a public Q&A.
Yeah, from the USCIS, ALE.
And they said, we're not going to issue this NTA within the 30-day appeal or 33-day appeal period to allow people to appeal.
Yeah.
However, in a question where they said, we can issue an NTA on a denied adjustment of status. We have an I-485 and it's denied. We may issue an NTA, even if you have another adjustment of status that's pending. And their attitude is, the problem we have is once we issue this NTA and this notice to appear, and it is issued, we lose control of it. We cannot take it back.
Yeah, that's the thing people should understand. You become the immigration court's problem, not USCIS's problem.
And let's assume there was another I-485 and they weren't aware of it.
Yeah.
So you need to adjudicate that before the court.
Yeah.
Now, there are strategies with the attorneys that can help you. For example, in a scenario like this, I would recommend that you would file a motion to reconsider, and in bold, we have another adjustment of status. Please don't issue an NTA, and then try to argue it. So even when they if they deny this adjustment of status, now they're aware of the other adjustment of status.
Yeah.
So it creates all kind of
you brought up something that's really good. It's about awareness. You know, one of the criteria that's, you know, you were talking about the employment-based denial, but the other one we didn't explicitly hit on was aliens not lawfully present in the United States are subject to other grounds of removability. So basically, USCIS will issue an NTA whereupon issuance of an unfavorable decision, a benefit request, the alien is not lawfully present in the United States. And so, I mean, you're talking about the concept of the very limited scenario of, you know, an I-485, two I-485s. I think there's so many more scenarios like that where USCIS has no clue as to, they're very much a left-hand, right-hand sort of agency where, you know, they've consistently demonstrated in the past, like, they don't know that you have other cases pending for you. And that's, I mean, maybe you hit that point with the I-45, but it's, you know, if you have, you know, H-1B, B-2 to H-1B. If they deny that B, there's a 1,001 ways where they've demonstrated in the past where they just don't have any clue what else is pending for you.
More questions, less answers. It's here. I think the only advice I can give people is, if your paperwork is in order, don't worry about it. But if you find yourself in a situation where it's questionable, don't do this on your own. Yeah. Get an attorney, because an attorney can probably solve this in a lot more efficient way with a lot better result than on your own. With that, Brian, we go to immigrationquestions.us.
Immigrationquestions.us, which is our fun little website where people during the week can send us questions on immigration matters, and we'll have them sort of first thing on our list at the beginning of this meeting right here.
Yeah.
So speaking of, we have a couple of them.
That are interesting?
Yeah, so we're starting from last Thursday. So from DeBarty. My priority date is September 2014 with EB2, downgraded as an amendment to EB3 in 2020 when you filed the I-45 concurrent filing, and tubbed back to EB2 in 2022 with employer A. I moved to employer B in 2023. How can I transfer to new employer B under the EB3 petition? In the last session, you mentioned you have to file 2 I-45 days, but for tub, dates are not current. So this is a great question, and I'm not sure there's a way that this DBRD can accomplish what they want. Because in order to do a tub to move to...
You can move it back here.
I'm sorry,
I lost it, yeah.
Sorry, apparently I like to see myself talking on the screen. My apologies. In order to do a tub, being back to, you know, to the employer A, I-140, EB3, employer A has to want you. And that's the problem you have. You can't just jump back on their I-140 because it's convenient to you. You are kind of stuck in that category you left employer A with.
But if employer A takes him back, what happens?
If employer A takes him back, as long as employer A is saying, hey, oh yeah, we'd love to have you back upon issuance of a green card, you can do it.
Okay.
Yeah.
And that's basically the bottom line. He does not have to move to employer A, but employer A has to be in good faith making that request.
Offering of employment. That's maybe, hindsight being 2020. It's one of the great reasons why you can have multiple adjustments, because you can only have one basis at a time for your adjustment, right?
I go back and I remember when we've given advice about filing multiple adjustment of status, and we were a strong advocate of that.
Yeah.
And there were other opinions that, hey, lawyers will just want to charge you more money. Remember that?
Yeah.
Lawyers want to charge you more money. They want to have. Why would you want to keep in your H-1B while your adjustment of status is pending?
Yeah.
Now we have this NTA.
Yeah. I'll take as many layers of protection I can get. Thank you.
Yeah. Go back to this other advice and tell them maybe you did not have the long experience in immigration law to have seen these things before surface.
I mean, I always tell people, I don't know what the future holds. All I know is that I live in a world where I don't have to. We're U.S. citizens. We don't have to worry about this. And I would feel really bad if I didn't let somebody know, here's the way you can protect yourself the most. Not everybody has to take the exact advice we give, but I'm not going to tell anybody to do anything less than protect yourself as much as you can. And you sort of roll back from there.
Let's take the next one.
So from Harsha. Hi, Brian and Sam. Well, Sam, I'm sorry. Go ahead.
No, you go for it.
All right. I seem to have the gusto here. Background: EB2 priority date: India, April 24th, 2013. Only have an I-140. Employers won't support another I-140 in EB3. Darn. Downgraded to EB3 in 2020. Upgraded back to EB2 in 2021 via TUB. Given my priority date will likely be current in EB3 at the end of the immigration calendar year, my employer advises against filing a TUB to downgrade to EB3, fearing USCIS confusion and case limbo. What do you think? I don't think that employer sounds crazy. I think that USCIS is not very good at taking any sort of request that is not
but if
forms of fees.
If he can save. How much time can he save transferring to EB3?
It depends upon where the dates are. If the dates are six months ahead in EB3 by that time, I'd say it's still probably worth the while for sure.
Okay, so too early to tell. Cross the bridge when we get there.
Yeah, I mean,
would that be a good answer?
I usually tell people, Sam, there's no 100% right decision to make because we're not sitting here with a crystal ball, and you're never going to know if you've made the best one because all you know is when you got your green card,
Yep.
You can't talk to the other version of yourself who got it at a different time, Yep. So from Igonazo.
Yep.
I want to respond to an RFE for an I-140 and also upgrade to premium processing. Can we submit the I-907 with the RFE response together? My lawyer says that she'll send the responses and send the I-907 separately. Is there a place where I can show him or her that sending both together is accepted? Thank you so much for your help, guys.
So why our good friend Ignoza, right? Igonza?
I read it as Igonazo.
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 Yeah. Why our friend Igonazo is second guessing his good lawyer?
Well,
why people do that sometime? Your lawyer is telling you the RFE is different than the premium processing upgrade. It's going to go to the same officer, but there have to be separate filings. You can put it in the same envelope. It doesn't matter.
You can put it. Context will upgrade in H-1B, for example, RFE to premium processing.
Right, but these are two separate applications.
Yeah, they are. Yeah.
Okay, so if the attorney is comfortable mailing them at two separate covers, it doesn't matter.
Yeah.
Let the attorney do what the attorney is comfortable. Now we've done it together.
Yeah.
But this is a distinction without a difference.
Yeah.
But perhaps the counter argument is do what the client wants, make him happy.
Maybe I'm interpreting the question differently because basically I'm reading it as my lawyer says I'm going to send the RFE response in first, and then I'm going to upgrade the case to premium processing through a separate mailing. You're sort of reading
concurrently, two separate mails separately. I think it's separately or together.
Yeah.
But you can do it on the same day.
Yeah, I see your point. As long as they get there, as long as both get there, you don't really have a problem.
The other point I want to make for our friend is how strong is that RFE response?
Yeah, I kind of have a problem with here's my concern with sending them separately, Sam. Let's say USCIS gets the I-907 first when you have an RFE outstanding, right? What do they do with that? I understand.
Nothing until the RFE
until the
comes in.
RFE response comes in, I suppose. Yeah. Okay. All right. It's a hypothetical I hadn't thought about.
Yeah. All right. Sounds good. So immigrationquestions.us is our website, and it allows you to put your questions. If you put them today, we'll try to catch them next time around, and it just helps get us to look at those a little earlier for you, and get you in front of the line.
Yeah.
All right. Let's take questions from our team here in
our crew
yes.
of viewers.
Yes.
Can I apply for an H-1 visa from underserved area? Yeah. I did not get selected in the lottery, and it's not a nonprofit organization. There are two criteria for medically underserved, and one is governor approved.
So this is a medical question, and I think I wouldn't have. Yeah, this is.
I think it's the cap exemption, sort H-1B cap exemption sort of question. No.
No, I think this is underserved area for medical underserved areas. So, and that's the question. There are two criteria for medically underserved area.
Yeah, but can I?
One is governor, one is approved.
But the question is, can I apply for H-1 visa from? And I did not get selected in the lottery.
You have to be selected in the lottery.
Yeah.
Unless it's exempt.
Yeah. Okay.
Nonprofit.
Yeah. I think they're saying that, hey, I'm working for an organization that's a non-profit one, and here beside the places in MUA on DHS website as governor's exception for MUA. It's a medical clinic. The short answer is no. You must the statutory requirements must be met to be a cap exempt institution, and they are usually not-for-profit research organizations or organizations affiliated with them.
And if Runyan, if we've missed this question, drop it in the notes, and we'll see what we can do. Or go to immigrationquestions.us. This is a perfect example of going to immigrationquestions.us, so you can write your question, articulate it in full. That allows us time to kind of look at it and maybe pick it for discussion next time, Runyan.
Yeah. So this one, SK Creations here is.
Hi, Sam Brian. Recently received an intent for denial. I'll give you a little break.
Yeah, please.
Hi, Sam Brian. Recently received an intent for denial of my current H-1B petition due to issue with wage level which is set to 2 instead of 4. My current H-1B valid from March 2026. I have been given April 2025 for denial response. I'll be transferring my current H-1B to a new employer with this time in addition to responding to query. Will there be any issue in future in my current H-1B?
If the petition is denied, please.
If the petition is denied. So the question number one is whether or not he's invalid I-94 now. Is I-94 valid or not?
Yeah. So
that's the first question for me.
Yeah.
On an extension, right?
Yeah, but this is clearly some sort of amendment because it says the H-1B is valid till March 2026. So that's a year into the future from now.
Got it.
So,
yeah, you're right.
but if it's an amendment, so here's my thought, Sam. If this employer filed as an amendment, so SK Creations could change.
Can withdraw. They can withdraw the amendment.
Yeah, but what if they've been so fine? Hey, we got to get you to work on this new project, right? This requires an amendment. We filed that H-1B for you, and you've been working pursuant to the terms of this new pending H-1B. Right?
So you're talking about new relocation.
Yeah, like a relocation, for example. And if you're working pursuant to the terms of the new H-1B, and that H-1B is determined to be not valid, are you not in violation of your status?
Well,
it's a real, very specific kind of attorney question, but
you can go back. You can go back to the old job.
You can attempt that. That's for sure. Yeah.
But I have to say that it is not a smart amendment to drop somebody from level 4 to level 2. And here's a scenario that might happen. This guy was, let's say, in Midwest and got moved to California.
I think it's a different type of RFE. It's the one where you file the LCA, right? I don't think there is any question about having been at level 4 in the past. I think it's this, and I've seen this maybe a couple times at the end of maybe middle of last year. It's, hey, you filed this LCA for this person at level 2 wages, right? We think this person should be at level 4 wages. Why? Because we did a visit to the end client or contacted them, and they said, oh yeah, this requires 10 years of experience, and a level 2 job does not require 10 years of experience. I think that's the kind of RFE I think that is.
Okay, possibly.
Yeah. We'll see.
We don't have enough information. That's possible. Yeah. The other possibility, the way I'm thinking, is that
you were here, you moved down.
This guy is making $100,000 a year in in Michigan.
Yeah.
Now they moved him to California, which the wage is 140, or the other way around.
Yeah.
Something like that, where they wanted to lower the wage to make sure that they don't pay him more.
Yeah.
So it's going to California. So California level 4 is 140,000. We can only pay you 100. We're going to do you as level 2.
Yeah.
We were doing you as level 4 before, and they're saying, what's going on?
I see. You're in Columbus, Ohio, where you're getting paid a level 4 wage, and you're doing essentially the same work elsewhere, and they're putting you down. I could. Yeah. That's a possibility. Yeah.
Yeah, that's a possibility. Be that as it may, but Brian's point is right on for you. If you're trying to transfer and you've moved already, I think USCIS may be asking whether or not that move is legitimate, because it's going to be retroactive.
It's one they can in theory ask. If you've already started working pursuant to the terms of that new H-1B, and then they say, "Oh, sorry, that H-1B is not valid," that's where I would start, worrying.
I mean, obviously, I'm thinking for him, and it's a complicated case to answer here, but I think the other thing is, do you have the next job? Are you ready to do it in premium processing while this RFE is pending, so you can play all your cards? So there's a lot of dynamics here.
And they say, well, I'm going to be changing to a new employer within this time, in addition to responding to the query.
Furthermore, do you have an H-1B stamp on your passport? Can you do consular notification? So there's so much here. If you can drop at immigration-questions.us a more detailed one and give us time to look at it, maybe we'll give you a better answer.
Yeah, I'd say my short answer to it is, it's probably not an issue of can they approve the H-1B, it's whether they're going to give you an I-94. And that having a visa stamp is really relevant to that as well. And it can come up, I think, is the short answer. There's no guarantees that it's not going to.
Let's take the next one. Hi, Sam. In one of the shows, you mentioned that CBP, if a green card holder is asked to sign a form to give up green card, you said she has the right to remain silent and speak with an attorney.
Keep on going here.
If green card holder does that, can the CBP detain them until they refer to a judge, like 1 or 2 months? I'm trying to understand the risk in that. The only reason that you can detain a permanent resident is if they have criminal background or a security risk, or a national security concern. Short of that, you'll be just giving a notice to appear before a judge, and they will not arrest you for something like that. As a matter of fact, sometime at there was a history of that a long time ago. I'm not sure they do it anymore. At the Canadian border, they hand you this and they don't explain to you what you're signing sometime. So be careful what you're signing about surrendering your green card. But yeah, you can refuse. And if you don't have any criminal background and there's not a national security risk, you're not going to be detained. That risk is almost non-existent.
Handing a notice to appear is it's just a document. It's not.
You go to the judge and trying to just hire a lawyer, and you are a permanent resident until there's a hearing, and you can leave and come back even furthermore as this paperwork is pending. But if there's criminal consideration or things of that nature, it changes the answer completely. But let's take the next one.
Yeah, well, it's sort of a question from the same person here, Dan. My friend is a green card holder living with a roommate, but she can't be added to the lease. I believe this is one of the factors that shows she has ties in the U.S. other than employment, etc. What are options to show that she rents in the U.S.? Please advise. I mean, my first answer would be a nice letter or affidavit from that roommate that says,
Is that a permanent resident case?
Well, it says my friend is a green card holder living with a roommate.
So a roommate is a green card holder?
Yeah, I know. Yeah, that's what it's unclear to me. My friend is a green card holder living with a roommate. But so she can't be added to the lease. Yeah, I'm not.
I mean, if the roommate is a permanent resident, her ties to the U.S. are job, car insurance, driver's license, bank account, mail that you receive.
Just receiving mail at a place, it can indicate that you leave there.
Yes.
Yeah.
All right, so we'll take the last one, Brian, here.
Oh well, yes, Sam's right. That's SK Creations was the one where I got the RFE on wrong wage level. Darn, I thought I was right on that. I really thought I was right on that one.
Well, that's your weakness, Brian. You think you're right.
I was just saying that they're not a good left-hand, right-hand agency. They very rarely look back at a prior case.
It's a move across state line. They dropped the and they caught it because they're not happy because they know exactly what the employer is doing.
Yeah.
All right, so let's take that last one, Brian.
Looks like a multi-parter here, but from the last person, that's good.
Lost my job during H-1B admin processing and re-entered in advanced parole, national interest waiver. Can I ship my passport for visa issuance by mail and use it with future employer instead of waiting for another admin pro? What is that question?
So I think I applied for an H-1B. Sam, I've proven myself wrong on these interpretations, but I think I have the answer here. I applied for an H-1B visa at the consulate. They said administrative processing. So, and the case is still administrative processing, and I said, fine, give me my passport back, got on the airplane, entered the United States with my AP.
Oh,
right?
can I mail my passport back?
Yeah.
And they said there's approval, they'll issue an approval?
Can I ship my passport for issuance by mail and use it with a future employer instead of waiting for another admin pro, though? What's...
use it with future employer instead of waiting for admin pro. Ahmed Hamid.
I think I know. I think he's saying, can I? Okay, they're going to put the H-1B once they issue my visa. I'm going to send my passport back to wherever I'm from. Right? They're going to put that visa in my passport, and then once I have that visa, can I use that for my work authorization? You know, show that I'm on the United States on H-1B status. That's my guess. Instead of waiting for administrative processing.
Here is my advice to Ahmed Hamid. Which one is the immigration question? Go to immigrationquestions.us, put your question in full detail, spend all the time you need to detail it. Let's bring it back and we'll answer it Wednesday. With that, we